shorthand legal dictation, speed with 100 words per minute, start. 12 dot. Leading arguments for the other side, comma, Shri Neeraj Kaul, comma, learned senior counsel appearing in SLP in bracket capital C numbers 19545-19546 of 2016, comma, emphasized that in the first part of section 26, comma, there is an absence of the mention of court proceedings, full stop. According to the learned senior counsel, comma, this was of great significance and would, comma, therefore, comma, show that the Amendment Act would retrospectively apply to court proceedings, comma, as distinguished from arbitral proceedings, full stop. On a correct construction of section 26, comma, according to the learned senior counsel, comma, the second part of section 26 takes within its sweep both arbitral proceedings as well as court proceedings in relation thereto, and would, comma, therefore, comma, apply to arbitral proceedings as well as court proceedings in relation thereto, comma, which have commenced after the Amendment Act came into force, full stop, para. For this purpose, comma, he relied heavily on paragraph in Thyssen in bracket supra and, comma, submitted that, comma, therefore, comma, on a true construction of section 26, comma, section 34 proceedings that have commenced before the Amendment Act came into force would be governed by the Amendment Act, comma, and arbitral proceedings which commenced after the Amendment Act, comma, together with section 26 applications made in relation thereto, comma, would then be governed under the second part of section 26 of the Amendment Act, full stop. According to the learned senior counsel, comma, no vested right exists inasmuch as section 34 proceedings are not appellate proceedings, full stop, para. In any case, comma, section 26 evinces a contrary intention and would take away any such right, assuming a vested right is involved, full stop. He countered the arguments of Shri Vishwanathan, comma, in particular, comma, by stating that the original intent of the 1996 Act was to minimize court intervention and to restrict the grounds of challenge of arbitral awards, comma, and inasmuch as the decisions of this court in ONGC versus Saw Pipes Limited in bracket 2003 5 SCC 705 and ONGC Limited versus Western Jaco International Limited in bracket 2014 9 SCC 263 had gone contrary to the original intention of the 1996 Act, comma, all that the Amendment Act did was to bring the 1996 Act back, comma, in accordance with its original intent, comma, by nullifying the aforesaid judgments, full stop. He added that the ground of patent illegality that had been added by the Amendment Act also differs from the said ground as understood in the earlier case law, comma, and has been added only qua domestic and not international commercial arbitrations, full stop, para. Learned senior counsel then argued that given the fact that court proceedings in this country take an inordinately long time, comma, the whole object of the amendment to section 36 would be stultified, comma, if section 36 is only to apply to court proceedings that result from arbitral proceedings, comma, which have commenced on and after the commencement of the Amendment Act, full stop. That this could never be the case is clear from a judgment of the House of Lords, comma, reported as Minister of Public Works of the Government of the State of Kuwait versus Sir Frederick and Partners, comma, which is strongly relied upon, full stop. Learned senior counsel also stated that there is no distinction between execution and enforcement, comma, and code enforcement, uncode under section 36, comma, is nothing but execution of an award, comma, as if it were a decree under the Code of Civil Procedure, comma, 1908, full stop, stop.